Hello and welcome to the Breaking Down the Different Methods of Home Care Deliveries, Agencies, Registries, Virtual Marketplaces, and Consumer-Directed Models webinar, presented by Pulcinelli, CareTime, and Ally. Today's webinar is being recorded and will be available for replay within 72 hours. Please use the Q&A box to submit questions to our speakers throughout the webinar. If you experience any technical difficulties, please type your question into the Q&A box and our engineer will assist you. I would now like to turn the webinar over to Market Advisor with CareTime and Ally, Derek Jones.
Thank you, Claire, and good afternoon, everybody. We'll advance the slide. Welcome to the webinar. We have an action-packed agenda today. In fact, the webinar was advertised as 60 minutes. I do believe we will go over, but it will absolutely be worth it. But here's what we intend to cover. We are planning to cover the agency versus the consumer-directed home care model. And you might say, well, what is the consumer-directed home care model? We're going to cover all the basics and the advanced tactics as well. There's a lot of legal and regulation implications on these models, even state-specific nuances. Angela will be covering those as well as state licensing requirements for the individual models. So if you're coming into this webinar wondering, I run one model of home care. Are there other options? Are those options available in my state? And what are the things I should be considering? We're going to cover that today in the agenda. Next slide. So your speakers today, you probably know Angelo Spinola, but he has over 20 years of law background. He is a shareholder and an attorney at Pulcinelli. He also is the chair of the Home Health, Home Care, and Hospice Board at Pulcinelli. So I first met Angelo maybe 10 plus years ago at a home care conference and quickly learned he was one of the top guys to go for anything legal in the home care space. His sessions, I was presenting as well, and I wish I had half the attendees that he had. His rooms are always full and very knowledgeable in this space. So Angelo, thanks for joining us today. These questions will be answered today. So we threw out a few of the questions that we received prior to the webinar. So I put a few of those on here. In the middle, which model of home care is the best? Can I run both an agency and a registry at the same time? What options are available in my state? And what happens if there's an injury to a caregiver? These are just some of the questions, but these were directly the questions you wanted answered, so we will cover these today. Next slide. And why are we covering this topic now? Well, no surprise, but the cost of care is growing for home care services. And when we say home care services, we're talking private duty, non-medical, and the other variations of how we describe home care services. I've put in a couple graphs here that you can see. The short of it is right now, assisted living is actually cheaper than home care in many markets today. When I first entered into the home care space 10 plus years ago, I actually managed a home care agency and a registry across multiple states. One of our top value propositions was home care is less expensive than going to assisted living. Now, when you take the national average, this is from Genworth's cost of care survey, and you put in that a caregiver who might need, let's say, 40 hours of care a week, home care is actually going to be more expensive and assisted living is cheaper. So it's where there's a lot of cost pressure on our businesses today. We also know that there is a massive shortage of caregivers today, just with unemployment and inflation going up. I'll also say there's an exodus of caregivers in the industry as well. Not only is there a shortage, but caregivers are deciding to leave. Also, that is just putting more price pressure on the home care industry as well. So with these things in mind, we want to make sure, we'll go ahead and click to next slide. So if that's the case, that cost of care is going up, caregivers are leaving the industry, I think everyone will come into this webinar today with a basis for thinking about a home care model, registry, agency, consumer directed. We're going to cover all the models. You might operate one, you might operate two, you might operate all three models, and you may not have all the information about all the models. That's why we're here today. But despite whatever model that you're running today, the goal of home care is to keep people home, right? And I know when I was managing a home care business, when I would sit down with the family member, most of the time the individual did not want to go to a facility-based care. That was the promise that the adult child made to their spouse, or that they told their spouse. And so the reason for covering the different models of home care today is that we hope that you might learn of a different option or multiple options to achieve this goal of home care if it is the right option for the client and the family member, and it is run correctly as Angelo will prescribe. So we'll do next slide. So imagine this scenario, and then we're going to hand it over to Angelo for pretty much the balance of the session here. But imagine this scenario. An adult child female is taking care of her mom. Let's say her mom's 82 and has early dementia. The adult child female has moved. She's a teller at a bank, and she used to be full-time. Now she's moved to part-time, which has reduced her income, and it's a strain on the family and her own marriage. Probably there's some infighting as well between the adult child siblings of who is going to take care of mom. And mom does not want to go to a facility, and she made her daughter promise this. Um, this is a scenario that my own mother went through with her grandmother just 3 years ago. It's exact, and our family went through this, and you guys are dealing with this every single day out there. So what do you advise, right? The obvious answer is we'd like for them to be in home care. At the end of this webinar, if you are in a state that supports the different models of home care, and if you run different models compliantly, which Angelo will cover, you could possibly have the option to say, well, did you know, in this case, adult child female, that you could actually get paid by the state to take care of your mom or dad to help supplement that income. And you, as a business owner, could potentially have a business model around that instead of not being able to refer that option. You could also have an agency option of home care, which of course is W-2 controlled, managed, and trained by the home care business. Or you could have a registry option, which you refer. And there are different reasons why you might use each model of care, depending on the acuity of the client, depending on finance and resources, and also depending on which models might be available in your state. But this is the goal for us here on the webinar today, is to potentially make you aware that more options are available. With that, Angelo, I'll turn it over to you.
Awesome. Well, thank you, Derek and Ally and Care Time for sponsoring this. Derek has been not only a client that I've worked with, but a longtime friend, master of the industry. Hopefully you've had a chance to work with him, but if not, you should. Great guy, and very, very nice businesses here. And really appreciate the opportunity, because this is something that comes up constantly, this issue of the various models. And I can't tell you the number of clients that we're working with now, typically, a traditional model, an agency that is moving towards a new model or additional model, whether it's a registry or a marketplace or a connection app, right? But there's just been so many. So what I want to start with, and Derek had mentioned, there's no possible way to cover this in an hour. So we're going to try to get you out of here by about 2:30 Eastern. Will be the goal. We are recording this. The recording will be, if you have to drop out at 2, the recording will be circulated to everybody so that you can catch the the tail end. And we just thought it was more important to give you a kind of a thorough assessment of all of this, instead of trying to rush through it in an hour. Just not possible. So let's start with the overarching kind of distinction. And when we're talking about a consumer directed model, that's a broad term that encompasses registries, virtual marketplaces, the consumer directed state models that Derek was mentioning. But let's kind of just talk about what the distinctions are, in basic form. So the agency directed, what that means is exactly what it says, that the agency is the one that's directing the care monitoring and supervising the caregiver, handling the scheduling, training, hiring and firing, right? And basically, ideally a white glove type service for the client. Generally, agency directed is more expensive than a consumer directed model. And typically within a market, similar pricing. With a consumer-directed model now, the idea here is that the consumer is directing the care. That's how it's supposed to work. The care recipient, or in some cases, if the care recipient isn't capable of doing that, the family member, whoever is hiring the caregiver, right? And the caregiver has a lot more freedom. The caregiver is responsible in an ideal setting, right? We can talk about reality versus perception, but it's the caregiver that's directing the care, that's identifying what and assessing the care that's necessary, or in some cases the state is doing that at a high level, and then letting the caregiver direct that care, right? Without a lot of instruction, supervision, scheduling, training, right? It's the caregiver has that responsibility, and the caregiver is typically treated as an independent contractor that's responsible for their own service, right? And their own qualifications. It's typically a lower price point than agency directed, so we're often talking here about the Hatfields and McCoys. Agencies and consumer directed don't always get along because agencies sometimes feel that the consumer directed models are either on an unfair playing field, right, where the standards aren't the same, so they can offer things at a lower price point, but it's not the same quality, not the same protection of the consumer. Sometimes you see consumer directed models that that they're in that vein in name only, but that's not actually how they're run. We are seeing more and more Medicare and Medicaid programs, particularly on the Medicaid side, lean on the consumer-directed model. One thing I will say is I don't think the consumer-directed model is going away. I think we're going to see an increase in consumer-directed as that increase in price continues to rise on the agency side, such that there are options, right? That there are options for the consumer to pick a service type that they can afford. But at the same time, there's a tremendous amount of regulation and variation amongst the states as to what models are and are not acceptable, and that makes it very difficult for home care providers of any sort, right, to understand what to do. One thing that is true about consumer directed versus agency, within agency, compliance is something that if you really focus on it and work towards compliance, you can be 100% compliant. I think with the consumer directed model and some of the subjective nature of the tests that we're going to look at, that's a much harder thing to avoid all risk. It's a much harder thing to do. Typically, these models have to tolerate some type of risk of liability based on the standards that apply, right? And it not being as clear cut. So for example, with an agency, that you have to pay for travel time, right? And you understand exactly how to do that and what the minimum wage is. And if you are doing that correctly, you're not going to have a travel time violation. Whereas when you're talking about an independent contractor, that's a subjective test that varies across the states and even the federal tests that apply. So you might think that you're doing it the right way. And in fact, a DOL investigator or IRS auditor doesn't see it the same way as you do. So the types of consumer-directed models are nurse registries, virtual marketplaces, the state consumer-directed programs, and I think you also have to add in the gray market, right? The gray market where you have caregivers that are not part of any kind of program or associated with any type of organization other than maybe their own business. If they have, if they're incorporated themselves, have an entity that they've formed, but these are the people that you find on Craigslist. Sometimes you can think of this as the under the table market, and that gray market can be very dangerous in that those folks are completely unregulated. and can do what they want. And you see, reports and stories all the time about individuals who have stolen from clients and the like, right? Abused clients. And I think the gray market is what we hope to avoid as much as we can, although we are pushing more and more caregivers and clients into the gray market. When I say we, the government, right, all the regulation that exists, right, the cost associated with care. Sometimes you see a client say, well, this would be easier just to do it myself and just hire somebody without an organization associated with that individual. Okay, so let's turn now to the different types of consumer-directed models and registries generally. A nurse registry is often you're generally talking about personal care, although sometimes there are skilled care. I've seen skilled care registries. A lot of times registries will have a skilled care, a registered nurse on staff. In some cases, that's required in some states, but oftentimes the work is done by CNAs or home health aides or companions homemaker type positions. But you really have the spectrum. Those workers are generally treated as independent contractors to the registry. It is questionable whether or not the consumer is an employer. That's one of the hot button issues. We'll touch on that a little bit later. And the concept of a registry is that the registry vets the caregiver if there are requirements in the state. Some states have licensing requirements for registries, some do not, right? That they'll perform for example, in Florida, the level 2 background screening, right? And all of the steps that are required to vet the caregiver, place the caregiver, and then the relationship is supposed to be between the caregiver and the client, right? Where the caregiver is directed by the client, negotiates with the client. The care is between the two of them, and the registry's role is administrative and purposes only. The DOL in recent years has been very focused on nurse registries. They've been focused on registries in Florida and in other states as well. This is an example of a case out of Virginia where a nurse registry was deemed to be the employer who had not paid for overtime, right? Was not paying time and a half. And the concept here was that not only did the registry perform the credentialing process, the screening process, but also was involved in the supervision and control and the direction of the caregivers. There was no good faith defense, which is rather surprising oftentimes for a registry because it is a subjective test, and particularly when there are rules and regulations around how to be a nurse registry. The good faith defense will apply. That's significant because basically that doubles damages when there's no good faith defense. And one of the reasonings behind the court was that Steadfast didn't get the right kind of legal advice, right? They didn't get thorough legal advice as to what steps should be taken to be qualified as a registry. One of the big misnomers that registries have is that because the state will license them as a registry and the state regulatory rules will allow for independent contracting, that means that it's a viable independent contracting model across the board. And that isn't the case, right? That doesn't always turn out to be that way because there are all these different independent contracting tests, which again, we'll get into here in a few minutes. So the state may say that these are independent contractors for purposes of the licensing body, right? And the state regulatory rules around nurse registries. But then the Department of Labor will say, under our economic realities test, you don't meet the same standard. So what the state does with you is independent of what we decide. And that's very frustrating for a lot of registries who aren't aware of that until they get a judgment like this. This was a significant case with over $7 million in damages. When I mentioned the liquidated damages, that's 3.6 million. So double liquidated damages for 1,100 nursing aides, LPNs, and registered nurses. So very, very significant award, and that lack of good faith defense, is what doubled the damages. Couple of things I always like to look at cases like this to identify what kind of issues the court identified as problematic, and one of them was that there were some restrictive covenant implications, right? Restricting worker mobility, which is a big no-no, right? The idea of having a caregiver that's supposed to be an independent contractor, meaning they can work for whomever they want, whenever they want, in any jurisdiction they want, right? Doing whatever they want because they're an independent contractor that's marketing themselves, not an employee of yours. So if you are restricting them through non-competes or non-solicits or anything like that, that creates, a real problem. So let's switch gears now to virtual marketplaces and just kind of talk about what the distinction is between a virtual marketplace and a registry. And generally, and this is probably the area where we're seeing a lot of expansion, the most expansion within the home care industry, where you have traditional models that are very interested in becoming virtual marketplaces. They've got matchmaking technology. So that one of the big differences between a virtual marketplace and a registry is that the platform is kind of the key component, that online platform or the software that's being used, as a marketplace to introduce the worker to the care recipient, right? And so the workers are on the platform, the care recipients are on the platform. There's a ton of different ones. Uber is an example, right, of what a general virtual marketplace looks like. Care.com or CareLinks or HomeCare.com are examples of others. There have been virtual marketplaces that utilize a W-2 model, but oftentimes they are independent contractor models, and there is generally less oversight in a virtual marketplace than there would be with a registry. And the idea is, hey, we create a platform. It might be a subscription service where you're paying a subscription, right? Or there may be an additional charge, right, for the actual placement and marketing, but the concept is that the software is doing a lot of the matchmaking work, right? And oftentimes, though, a virtual marketplace will conduct the background checks and do some of the screening that you would see a registry do as well. Oftentimes, with a virtual marketplace, it's open broadly. It's not geographically restricted, right? Because software can touch anywhere. And that has created a lot of issues for virtual marketplaces around the regulatory environment, right? Does a virtual marketplace have to be licensed in, say, Florida, that has nurse registry registrations, right? That has, nurse registries have to be licensed in Florida, right? Does a virtual marketplace that's effectively, in the state's eyes, doing the same type of thing, right? What about, and what we're seeing with virtual marketplaces as the states are becoming more and more savvy to the model and actually modifying some of the regulatory licensing requirements to make sure that virtual marketplaces are included. Because when you read the regulatory rules, they're not considering, they're older, right? They're not considering virtual marketplaces, and the Ubers of the world, the Lyfts of the world have sort of paved the way for a virtual marketplace. It's another regulated industry, transportation, but you're seeing that impact home care and home care licensure as well. And just a quick little aside to answer the question, it's a state-by-state analysis. Some states are very favorable for virtual marketplaces, some states are not, and that work has to be done before entering into, or should be done by a virtual marketplace before entering into a jurisdiction. So a lot of times the focus is on, hey, we have the software, we can turn this thing on. How about it? Can we just launch? And our approach has typically been, hey, let's take a look at this and focus on individual marketplaces and where you really want to get started, and then expand a little more slowly than perhaps what you would like. Sometimes that requires communication with the Department of Health, right, to find out what their view is on the virtual marketplaces because the regulations are not entirely clear. But there's typically a variety of different types of licenses. Sometimes it's a simple business license, sometimes it's a staffing license, actual healthcare license, right? Or a registry that is necessary. So, and sometimes there's none at all. So just going to depend on the state. But the concern about marketplaces is the lack of oversight, right? And this is an example of one of the marketplaces that was recently written up for allegations of abuse both ways, right? In all settings, where sometimes it was the worker alleged to abuse the care recipient. Sometimes it was the care recipient alleged to abuse the worker, right? But the concept being that as is the wild, wild west, because you are putting a vulnerable group in contact with relative strangers, right, without a tremendous amount of oversight. And that's generally the agency argument or the state argument when the state is anti-independent contractor relationship, is that somebody really needs to be minding the ship, and we shouldn't, when we're talking about the elderly and the disabled, we shouldn't have unsupervised individuals, even if they have been vetted through background checks, in that position, as it's too dangerous from a theft perspective, safety perspective. You get the drill. Okay, and then the last model I want to talk about, I think you understand what the gray market is the consumer directed type of program, and this is where the state is involved, and the state will often register certain agencies or independent contractor models, whether that's a registry or somebody else, to serve as the intermediary, the fiscal intermediary between the consumer and the caregiver. Sometimes the state runs these programs directly, but it's the same kind of concept, except for now the state is the one that is serving in that sort of organizational role. The state may be the one through their program to identify what the care is, the care plan that's needed, what the hours are, what the services are that need to be provided. And these models also run into issues, right? There are issues, right, where the state itself may be deemed the employer. And here's an example. We're going to talk about joint employer here in a little bit, but here's an example of where LA County was accused of being a joint employer for the provision of in-home supportive services directly to consumers under one of the state programs. And this was, this is an example of one of the tests that applies for employment, right? And this is called the Bonnet test, which is used sometimes in California. Sometimes we see it's AB5 in California, and sometimes there's an exemption. So California is particularly challenging when it comes to independent contractor status, and quite a morass as a result of a lot of the legislation, the Uber litigation, and this is a continuing sliding scale, which is another thing you'll understand about independent contracting, is the rules today are not necessarily the rules that will be in place tomorrow or the rules of yesterday, and the interpretation of those rules is also going to be dependent on what the agenda is of the interpreter, right? So if you're in a place like California that is more liberal in nature, there's a more significant likelihood that somebody called an independent contractor is not going to be an independent contractor, despite what the objective analysis is under the law, as compared to a state like Texas, where the standard is different, but those interpreting the standard have a different bent as well. And the same can be said at a federal level. When you look at the Trump initiatives, Trump changed the independent contractor test to be a more conservative test for establishing a viable independent contractor. And now that standard is changing back under the Biden administration to a more difficult test for independent contractors, right? That is normally going to lean towards an employment model. So this is not, something that is black and white. And you can look at the Bonnet analysis, and you're going to see, this is a modified version of economic reality, which is what applies under federal law with the Fair Labor Standards Act. But you can see some of these tests are objective, right? Supervised and controlled employee work schedules or conditions of employment. Well, what does that mean? How do you determine whether somebody was controlling employee work schedule? There's going to be factors that are probably in favor of that, factors against it. That's what I mean by a subjective test, right? Is you're gonna throw a bunch of stuff at the wall, and then the decision maker is ultimately going to answer the question of, well, was that enough control to satisfy that these are employees and not independent contractors? Who's doing the hiring and firing? You're going to see some, despite the tests that we're looking at, these are often the elements, right? Who determined the rate and method of pay? Who's maintaining the records? And long story short, as LA County was found to be the employer, right? And the reason for that is they exercised control over wages. They were helping to negotiate wages on behalf of the caregivers, choosing the method of payment. They were dealing with the care plan and the hours, right? They set the guidelines to figure out how many service hours there would be. They identified the service types based on 25 factors that they could choose from. And they also maintained records on behalf of the caregivers and provided training, which is another important factor, right? Is who's providing training, and they are also giving guidance. So this is a big one in the franchise setting, right? The county was helping employees answer questions about their overtime and what they're paid, and basically giving them the equivalent of legal advice, right? Which is a factor in determining whether somebody is a employer or a joint employer. So even though the county was not the statutory employer, they were found to be the employer. So just keep those things in mind, and that is why franchisees. I saw there's a lot of you on the phone or on the webinar that you might get frustrated when you go to the franchisor and say, "Hey, I need some legal advice on this, or I need legal support on this," and they say, "Well, call Polsinelli, or you've got to go retain your own counsel and get that answer. We can't answer it for you." It's because they don't want to be the employer, right? A joint employer. Okay, so let's shift gears now and just talk about what some of those varying standards are, and just kind of take a high level approach. Just what I want to do is just give you a flavor of the distinction in determining whether somebody is an employee or an independent contractor, and make sure everybody recognizes how that can vary. There are standards, and there's over 100 different types, well over 100 different types of independent contractor and joint employment standards that apply, right? The standards are often different for taxation, right? And whether somebody is an employee for tax purposes, workers' compensation, benefits, overtime, unemployment, discrimination, they'll have a different standard. So this is just giving you kind of a quick overview. And Massachusetts is a great example. They've got 4 different tests just in that one state for tax, unemployment, workers' comp, and wage hour, right? 4 different tests that apply. So you might be an employer for purposes of pay practices, but not for purposes of unemployment, right? That can happen, and that often does happen. And often you see hybrid approaches in a state where you might have an agency that treats itself as the employer for purposes of unemployment payments, right? And unemployment, but for purposes of pay practices, they say that they're an independent contractor model, not required to pay overtime, and they may be accurate in that. And that's because the standard for unemployment purposes is much more difficult to satisfy than the standard for pay practices, or vice versa, right? But you see all the different tests here that apply across the states, and we track all of this and figure out which states are viable for these different types of tests and which ones are not. But just to give you a quick flavor, you've heard of the 20-factor test that the IRS employs, and the general criteria here of the IRS test is right to control. How much control is there? And it's a subjective test, right? Again, another subjective test, right? Degree of business integration, continuity of the relationship. That's continuity. I can read, folks. I can read. It's been a long day already. Continuity, and that's normally determined by a year or so. If it's more than a year relationship, and think about your relationships if you're a registry, caregivers that have accepted services on behalf of the registry clients for more than a year, right? You probably have a lot of them. Well, that's going to be an indicia of employment. But the registry argument is, well, it's sporadic. You sometimes they work with us and sometimes they don't. They market themselves across many different registries and individually. And so we might not see a caregiver for 2 or 3 years, and then they'll be back and accept assignments, right? Accept opportunities. So you see that these things can be weighted differently. And that's the point. Now, I will mention, I think this is important. It's beyond the scope of what we're doing today. But under tax law, IRS law, right, federal tax law, there are safe harbors in the form of Section 530 of the tax code and 3506 that are bright line objective tests that keep you away from this 20-factor subjective test. And anytime you can find a safe harbor or a bright line test where you just have to establish that you've met the criteria, that's always a great thing to do, right? That's always a very helpful thing to do. All right, shifting gears now to the Fair Labor Standards Act, right? They utilize something called the economic realities test. This is just federal overtime law, right? And minimum wage law, right? And these are the 7 factors. This test is also changing, right? This is likely going to change as well in a manner that will make it easier to establish that somebody is an employee and not an independent contractor. And that's one of Biden's initiatives. We'll probably see that happen in the next 6 months or so. That proposed change is already out. It's been commented on, and now we're waiting for the rule to be issued. I expect that it will be issued. And here's the modification that we will see, and they still refer to it as economic realities. So the argument is it's a refinement of economic realities and not a change. But when you look at what is changing, I think it is different, right? So for example, one of the modifications that I think is going to be challenging for a registry model or a consumer-directed model in general is that if there is a requirement that is imposed on, and this is how the proposed rule reads, if it's imposed on the worker so that the worker has to do something like a background check or something like that, or the registry has to maintain records, for example, records about the care and the hours and things like that, but it's because the state required it according to the proposal from the DOL. That's still indicia of employment because it doesn't matter where that direction is coming from. If the direction is coming from the state or some third party versus the registry itself, that used to be a pass. It used to be, well, the registry is not the one controlling the caregiver, it's some other third party, and that shouldn't factor into anything. According to the new proposal, it would. Same thing with the ability to control, right? So think about this in a franchise perspective, because by the way, the independent contractor test and the modifications to the economic realities test for independent contractor purposes is going to be the same as how you look at joint employment under the FLSA. So that's very, very significant for all franchise models. So reserved control under the proposal will be enough, and the NLRB is doing the same thing. We're expecting to see that change come out probably this week, where the joint employer test is changed. If you have the ability to control, even if you're not exercising that ability, so I reserve the right through, say, an agreement or my franchise agreement or some contractual agreement to exercise control over you, and I'm not actually doing that, or your employees, but I'm not actually doing that, that's still going to be indicia of employment. So a very significant changes are underway, and this is just an example. You can see from the DOL, that they're very, very focused on independent contracting. If the nature of a business requires a company to exert control over workers, then the company must hire employees, not independent contractors, right? This is the basis for why some of the changes are being made. I think I've just covered sort of what the impact is, but let's cover it in a little more detail. So this is going to affect staffing, right? Anybody that's involved in staffing, whether you're staffing in the home, especially if you're staffing a facility, you're not going to be able to use independent contractors. Arguably, you can't use independent contractors now for facility staffing, right? If you're calling them independent contractors and nobody's the employer, that's a problem. I'm going to show you a case in a little bit here that focused on that and focused on the facility and liability for the facility in that scenario, not the staffing company, right? So facilities have to really, really monitor who is staffing for them. It will impact the franchisor-franchisee relationships. It will impact personal liability on cases that the DOL brings, where the DOL always names a CEO, or when plaintiffs' lawyers bring an individual case not only against the agency but against the owner, right, under a joint employment theory, right? It will affect quite a bit in this industry, and obviously it will impact the virtual marketplaces and the other consumer-directed models, registries and the like. There is guidance that it currently exists that is probably the most significant and important guidance for any consumer-directed model. It's directed specifically towards registries, but it is applicable and important for virtual marketplaces and the state programs and everyone else that is utilizing any alternative to a W-2 relationship. And this guidance, one of the questions we often get, and I see that there are questions populating, and you can ask your questions, and if we can get to them, we will as best we can, but I'm hoping to address as much as I can here, given the length of the presentation itself. But one of the questions that comes up a lot is, well, what happens, the Field Assistance Bulletin referred to as the FAB, what happens when this new rule comes out from the DOL? Is that going to eliminate the FAB? No, I don't think it does, because the FAB is also utilizing the economic realities test, and the DOL is taking the position that they really aren't changing but clarifying the economic realities test. So as I just mentioned, there's some problem with that because there's some inherent inconsistencies between the FAB and at least the proposed rule. We haven't seen the final rule yet. There have been a lot of comments to change the proposed rule, so it could be that the DOL changes it some when it's ultimately issued, right? But we'll see. But right now, there's inherent inconsistencies, and the question is, well, which one controls, the new standard or the FAB? And the FAB is focused directly on home care, right? This is home care, so I would think that the FAB is going to take precedence, but we'll see. That's going to be an issue that is likely going to be litigated. But what I would tell you is any consumer-directed model must know this FAB inside and out and borrow language from the FAB, right? In all your compliance materials, train on the FAB. Remember, we looked at the Virginia Registry, where the Virginia Registry didn't get a good faith defense and had to pay $3 point whatever it was, $6 million in liquidated damages. Had they been using the FAB, that wouldn't have happened. They probably wouldn't have had liability at all, right? But certainly they should have been able to establish a good faith defense, right? And the good faith defense not only cuts off the liquidated damages, double damages, it also reduces the statute of limitations from 3 years to 2 years. So what's in the FAB? It covers things like background checks, hiring and firing, and provides guidance. In the interest of time, I'm not going to go through all of these. I do other presentations on everything that the FAB requires, the 10 factors, but let me just kind of give you the cliff notes today of what, and I want to get into kind of the practical side of things here. I've hit you with a lot of law. I know your head is spinning, and how do you figure all this out? So here are some of the common themes, both from the FAB and a lot of the various state laws. So care plans, registries should be very careful about, and when I say registries, let's just call this consumer directed models, right? All the models, right? The FAB is focused on registries, but again, it would apply to virtual marketplaces and everyone else. So the caregivers shouldn't be getting a lot of instruction about how to perform the work, how to do the care, because the idea is the consumer directed model is not in the business of care, they're in the business of matchmaking. So if they're creating care plans and overly focused on developing a plan of care for the client, right? What are they in the business of? Matchmaking or caregiving, right? Remember what happened to LA County? They were the ones that were setting the plans and the hours and all of that on behalf of the caregivers. And the court under that joint employment test said, well, boy, you're really under control here, and you're telling them what to do and how many hours to work and what they're going to get paid. You must be the employer, right? There should be no monitoring or supervision of the caregiver's methods or work habits. We see a problem all the time with registries, figuring out what to do with poor caregivers, those that aren't doing a good job. They're showing up late. They're getting complaints from the consumer, who's really the one that's supposed to be dealing with the caregiver directly. Are you going to take that caregiver off your registry? And is that now the equivalent of terminating the caregiver, right? Who's making that decision? Is it the client or the caregiver or the organization? These are challenging things. Remember, I said before, right? It's very subjective. I'm not suggesting that for these models, this is an easy answer, an easy thing to just resolve. You can't wave a magic wand and have no involvement with your client, right? I haven't seen a registry that can do that. So there are gradations of what you can and cannot do, and a lot of sort of magic that goes into the formula for determining how to make your model as compliant as you can in whatever jurisdiction you're in. And that needle is going to be moving differently in what you should and should not do, depending on the actual law in your states, right? So we're covering and talking mainly here about federal pay practice law, right now. So we talked about restrictive covenants, non-competes. Those are a bad idea to use anywhere, right? Whether you're in Florida or Maryland or Virginia or wherever else. When you're talking about independent contractors, they should be open and available to work for whomever they want, wherever they want, without you saying, well, if you go here or go there, that's a violation. So you need to be really careful about that. I do think that in many cases, it's appropriate in your client service agreement to have a placement fee, right? A direct hire fee. It should not be a penalty. It should be a alternative to services, just like a headhunter will charge. I think headhunters don't like that. Placement agencies, I'm sorry, that was barbaric of me, but you know who I'm talking about. Who is being informed of late arrivals, call outs, things like that, substitutes? Is that between the client and the caregiver, or is the registry responsible for determining who's going to replace the caregiver, for notifying the client, right? What the DOL does when the DOL is investigating a consumer-directed model is they look for how much, particularly after placement, how much involvement does that organization have with the caregiver and with the client, right? That is in administrative services, right? So that's why you see businesses like Ally, right? Ally is one of the I think probably the premier company that services registries and helps registries and consumer directed models outsource the issues, right, that the DOL typically is looking at, right? That gets them too entangled into the relationship between the client and caregiver. So the registry or the consumer directed model can say, well, we don't do that. That's a third party that's involved in the billing, or that's involved in the scheduling, or that's involved in the payments and the issuing of the 1099s and things like that, right? So that's the concept, is to offload as much as you can as a registry to others, so that you can minimize your interaction post-placement. Okay, so hiring and firing is a big deal, right? And the line of demarcation here is that that relates to how opportunities are communicated, right? Are opportunities communicated to everyone, or is there a subjective element that the consumer directed model uses where we say, well, we're going to call this handful of caregivers because they're the best caregivers. So we're gonna give the opportunities to these caregivers and not others, right? Or we think this caregiver is a good match, right? Now who's doing the interviewing, right? Is it the client, or has the consumer directed model that's not supposed to be involved in hiring and firing, vetting subjectively that caregiver to place them with the client, right? And then we talked a little bit about delisting from registries and eliminating. Now, if the state is doing that, the state says this person is no longer qualified because they haven't maintained their license or their training, or they've done something where they can't pass the state required background check, that's a different animal. But if you are independently eliminating people due to performance, that creates an issue. Setting the rate of pay is a major factor, right? Who is doing that? Who is negotiating, right? Are you using the same rate, charging the same rate to clients, communicating what that rate is to clients, not on behalf of the caregiver, but because you set the rate? How do you distinguish between those two different things? Serving as a liaison, right, between the client and caregiver versus the one that's actually setting the rate, and how do you actually establish that you're serving as that liaison? Or in the case of Ally, I think Ally's got a great rate sheet where they document the rate negotiation between client and caregiver. So those are the type of things that the Department of Labor and others look for, and the way that you structure your payment, your compensation as a consumer-directed model really makes a difference. And we're not covering today like referral relationships and that type of thing, but that's another major impact, right? That's a major issue when it comes to the regulatory environment. I'm talking, you can't see because my hands are cut off, but I'm really talking with my hands now because this is a major one. We're doing a ton of work with clients that have subscription services, placement services that are flowing through an agency or somewhere else with a referral relationship, and you need to really be careful as to how you do that, right? And some think that, well, as long as government reimbursement isn't impacted, it's not going to impact our model, and that is not always the case. These are called anti-kickback statutes, and some states like Florida, for example, have all payor statutes, so that even in a private pay situation, if you're getting referrals and paying for those referrals, right, in some instances that's going to violate the law, and the penalties can be criminal, right? It can be very significant. So if you've got any kind of referral relationship, you should really have that carefully looked at by healthcare regulatory attorneys. But independent of that, the pay structure for pay practices, right, for the determination of whether you're an employer under the FAB, under the FLSA, right, the economic realities test, is also somewhat dependent on who is paying the caregiver. How are you charging for your services? How long are you charging for your services? What the DOL would really like to see is a cutoff, right? The idea is that you have a set fee, right, a set cost, right, including your margin of what you should recover, and after that, then you should be out of the relationship. So what they'd like to see is, we're going to charge this much over a certain number of months. This is how Illinois does it, for example. They say you can only charge a fee for so long, and then you have to stop charging that client, and then you can charge a new client when that caregiver comes back around for another opportunity, but you're limited in how much you can charge, right? And that's ultimately what the DOL, what they probably have the biggest problem with, and that is not how most consumer-directed models work. Normally, they continue to charge throughout the life cycle of the relationship for however long it is. So if you've got a 3-year client, that client is charged for all 3 years. So you've got to be artful in how you handle your payment structure. And again, I'm not giving you solutions to everything because it is complicated and there's many options and it's state driven. What I'm trying to do here is just sort of give you the field, right? Give you a picture of the field as you think about these models. And you might be thinking that I'm saying, well, don't do anything but an agency, and that's not what I'm saying either. What I'm saying is that it's an area that's highly regulated, that it's consistently changing. You would have to, if you want to run a model like this, you have to be able to tolerate some risk, And then what you really need to do is do the work, put in the legwork to understand what the requirements are in your jurisdiction and protect your model the best that you can, right? Take steps to make sure that you're using compliant materials, that you've got compliant practices, right? And that's going to take some work, right? You can't just turn a switch on and say, I've got great software, so I'm going to run this, right? It's a little more complicated than that, as law typically is, but this area in particular, right, is the case in healthcare. And by the way, we are going to cover some. This is why we extended our time. I know we're coming up on 2, but I wanted to go through some of the compliance techniques and some of the things that you should consider and sort of the no-nos that apply across the board. So the last piece I want to cover before we get to that is the various licensing issues, right? So you've got all the law, the state law about, well, what is an independent contractor versus an employee? Independently, you have entity level licensing requirements and regulatory requirements that may require you to have a local office in a particular state if you're going to provide matchmaking services, that may prohibit you from providing matchmaking services with independent contractors, right? So you have to look at not only the law, but also what the state regulatory environment looks like. So here's an example in Illinois, right, where you first look at what is the law on an independent contractor test, right? And for wage hour, when you look at what the test is, very similar. It's a state-driven test, but very similar to economic realities, degree of control, extent of relative investments, right? So that's the profit and loss, issues, right? Permanency of relationship. Remember those from the economic realities test that we saw before. So borrowed heavily from that. When it comes to unemployment, though, right, we're looking at an ABC test, and that B part of the test here, right, the individual must perform services which are either outside the usual course of business or performed outside all the places of business, unless the employer is in the business of contracting with third parties for the placement of employees, a placement agency. Said a different way, what the ABC, the B part of an ABC test typically is asking is the worker that you're placing integral or important to the service that you're providing? And that is a really difficult test to pass. So Massachusetts, for example, is an ABC jurisdiction. California is an ABC jurisdiction in many ways, right, for many industries. Really, really challenging, because you have to say, right, as a, let's just take the argument of the state, a care provider, the only business that you're in is providing care, to consumers, and you do that with caregivers, and you're going to now have to argue that the caregiver is not integral to the business of providing care. Impossible, right? The only thing you can argue is that you're not in the business of providing care. You're in the business of matching people to provide care, right? That's the only way, and that, depending on the jurisdiction, often is not an argument that works, because what the state or the court or the DOL will say is, all right, well, without your caregivers, how much money would you have made last year? You're saying that they're not integral to your business. If you didn't have caregivers, what business do you have, right? You say you're in a matchmaking business. Tell me about matchmaking if you're matchmaking somebody other than this position, right? So somebody that wouldn't be integral to your business would be if you contracted for janitorial services, right? You're not selling janitorial services. You're selling caregiving services, right? So you see the distinction. But what I really wanted to show you here with Illinois is the distinction, right, between the law and what the tests are for independent contracting on an individual basis, and then independently what the licensing laws require, right? So home nursing placement agencies and home service placement agencies are businesses that secure work for hire for persons seeking work or workers or employees. The term includes private employment agencies and any other entity that places a worker for private hire by a consumer that is in that consumer's residence for purposes of providing home care services. So clearly that is covering home care registries and agencies, right, that are utilizing independent contractors, and the maximum contract duration is a year. And the placement agency can only charge a one-time fee. right? So that's that what they're doing is kind of shifting that to a placement agency. You still charge that fee over time, by the way. You can say, here's the fee, and you're going to pay it out over 12 months. But you're limited to a month, right? And New York, very similar. I think New York is even more difficult. My personal view of New York is that you're not going to be able to provide independent contracting matchmaking services in general, and I don't provide legal advice on these things because that gets me in a bunch of trouble. And there's a slide at the end, which I'm probably not going to have time to show you, so I'll just say it. I'm not providing legal advice. These are general concepts. All right, but understand that the New York position is that matchmaking like this, whether it's a virtual marketplace or a registry, requires a LIXA license, licensed home care agency, services agency, right? And you're not getting a LIXA license right now. If you know anything about New York, it's not happening. If you don't believe me, look at this case. This is a 93 case where there was an individual operating a business out of her home, providing matchmaking services effectively, right? And that's all it was. There's almost no touch, right? And basically, the court shut her down, said you need to have a license in order to do what you're doing. So if that's the case for a woman doing a little bit of matchmaking out of her home, what are they going to say about a virtual marketplace that has a sophisticated platform, right? Or a registry that has a staff associated with it, rather than someone that's knitting in their living room and making some calls, right? I'm not going to belabor all this because of interest of time, but New Jersey also has some challenging licensing rules and applies the ABC test, so be aware of that. And Georgia as well prevents home care providers from using independent contractors for CNA services. So you've got to be very careful in Georgia as well. We actually, by the way, for those, I know that some of you have national platforms, some of you subscribe to this already, but one of the things that we have at Polsinelli is a database that identifies all of the states that are favorable and not favorable, both from a licensing, regulatory perspective for virtual marketplaces and registries, right? It kind of identifies what license you need to have. It's very helpful, and it's one of these adjustable deals. So you pick your regulatory element. You want to know about licensing. You want to know about what is the test, for example, for workers' comp, right? It tells you what the different standards are. So pretty neat thing if anybody needs access to that, and we can do it at an individual state basis or at a national basis. It's just a subscription service that we provide, and we are licensed for it, if you were wondering. Okay, shifting to joint employment standards. They are shifting. They are moving, okay? This is really, really important. I mentioned this earlier in the conversation when we're talking about all of the issues and problems around joint employment, all the impact of changing joint employment standards. So that's happening at the NLRB. That's happening at the DOL, right? We are seeing joint employment eroding such that the statutory, even if there is an employer, right? Like in the case of franchisee and franchisor relationships, or parent subsidiary, or staffing business, right? Versus the business that's being staffed, right? There's an erosion now of that separation of employer, such that what it means is that not only is the statutory employer potentially liable, right, for any type of pay practice violation or whatever the misdeed is, but others, whether it's the individual owner or the staffing company or the franchisor, can also be held joint and severally liable. That's the concept of joint employer, is instead of dividing up the liability and trying to figure out who's responsible, we'll make everybody involved responsible, right? In a really simplistic nutshell, that's what we mean, right? Is that, hey, you were involved enough with those workers that you're a joint employer along with whoever the statutory employer is. This applies also in the world of independent contracting, because the joint employment standards are generally the same thing, like economic realities. as the independent contractor test, right? So, well, how involved were you with the independent contractor? And if you were involved enough in the supervision or whatever the hiring, the setting of the pay rates, whatever the standard is, then you have responsibility as an employer, and your client actually may be a co-employer, right? They may be an employer with you. So the more involvement you have with the worker, the more likely it is that you are a joint employer. This is particularly challenging for the smaller businesses, whether it's an agency or a registry, right? The owners of the smaller businesses often are pretty involved, right? And might be involved in hiring and firing and scheduling and setting whatever the pay practice is or whatever the issue is that is the one that has led to the complaint, the lawsuit, the investigation, right? It's not this building here, right, that made a decision. There's somebody that made a decision that we're not going to pay overtime, or we're going to pay less than minimum wage, or we won't pay travel time, or we won't include on-call premiums into the regular rate, right? And that individual is the employer right along with the organization. That's the concept, right? So you want to really, really think about how you've set up your organization. So a question that commonly comes up, if you are treating workers as independent contractors, and if what the consumer directed model is that the consumer is supposed to direct, right, the worker, is the consumer then potentially the employer? And I think the answer to that question is yes, right? And it's probably important that your clients understand that. And that's also true, by the way, whether you're an agency or a registry or a virtual marketplace, right? If the client is involved in any kind of discipline, any kind of, hey, I want you here at this time or that time, I'm going to give you a raise, you're doing a great job, I'd like to give you an extra $1 an hour, whatever it is, they can be held as a joint employer. Now, I want to say this practically, right? When we're thinking about joint employment, remember the concept of it. Why are the standards changing? Why is it getting easier and easier to establish joint employment? Is it to go after the client? No, that's not the goal. The goal is to go after the big fish, the franchisor, right? The parent, right? To, instead of saying, well, it's not me, it's him, and having this game, right? The government wants to say, look, I don't care. You're all the employer. But are they really going to hammer the consumer? Not very often. Does it happen? It does sometimes. It does sometimes, particularly around tax issues. That's normally, if you're going to see one, that's normally where you see it. There are exemptions that apply in home care for the consumer that don't apply to third-party agencies that are deemed employers, like a live-in exemption, like a companionship exemption. But the reality is live-in is one thing, but companionship is not a service that is often used. True companionship, it's normally care that's being provided, which would require overtime even at the consumer level, right? Unless it's a live-in, somebody that truly lives and works at the same place. So it can happen, and it's a threat that that the DOL will sometimes make, and the IRS will sometimes make. But where I've seen it is, somebody that's got a household of, let's say an actor or something in California, it's got a bunch of people that are being paid under the table or something like that. So, but the answer to the question technically is yes, that can happen. And the other question I wanted to cover that we hear a lot: can my organization or a facility or a facility my organization provides staffing services to be liable under a joint employment theory? And the answer to that is yes also, right? So you want to be really careful in staffing arrangements, particularly when you're staffing facilities, as to how that arrangement is made, right? Because if you think about it, the staffing business is often the statutory employer, right? They say that we will employ these people, but we're going to give them to you. And then a lot of times the business that has been staffed is the one that's directing and controlling that worker, right? And maybe that worker goes through an orientation at the staff facility. Maybe that worker goes to trainings, lunch and learns, and things like that at that facility. Maybe the facility supervisors are the one that's telling that worker who to go see and what to do and how to do it, and they're wearing the facility's badge or a uniform, right? All those are factors in establishing that that facility is actually an employer as well. And this case, I really want you to pay attention to. This one's wild. 40 million, allegation of $40 million in unpaid overtime at the facility level, right? So you had a staffing agency. The staffing agency was treating the workers as independent contractors and saying, hey, we're not the employee of these workers, but we'll provide them to you, right? But they're 1099. Facility believes, well, they're 1099 or doesn't check. I don't know which of the two is true, but oftentimes it's that the facility hasn't thought about this because they think, well, I'm getting them from the staffing agency, so the staffing agency must be responsible. Well, that's not what the staffing agreement said. Make sure if you have a staffing agreement that is reviewed by counsel and you know what, regardless of which side you're on, that you understand what's your obligation and what is the staffed facilities obligation, right? Who you're staffing to, what is there. That is so critically important. Who's indemnifying who, because you can't control who the worker or who the government sues. They might sue the staffing company. They might sue the business that's being staffed. In this case, because the agreement said, probably unbeknownst to the staffed facility, that the facility would be responsible. And guess what? The DOL wanted to settle for 19 million. There was a counter for 14.2, and eventually you had a settlement of 15 million, with 10 million to be paid out over 90 days, right? So the staffing business wasn't even a party in this case. It was only the staff business, right? That is very, very scary for staffed businesses, right? And it just, I mentioned this, make sure that you are reviewing or having your staffing contracts reviewed very carefully, especially, if you're not the one that drafted it, right? If you're receiving it from the facility, or if your facility receiving it from the staffing business, and just make sure you also understand what is the staffing agency doing? Are they using 1099s or not? And if you're using, I mentioned this before, 1099s and you're staffing into a facility, a hospital, long-term care, whatever it is, you better be careful there. All right, because the DOL's position is typically that is a misclassification situation. Okay. All right, what else can we do? You also want to make sure that the vendor is vetted, not only with respect to how they have their workers classified, but also for solvency, because we can put a great indemnification language in your contract, but it's only as good as the solvency of the business. I had a big case where we had an excellent agreement that made the staffing company responsible, but what happened was the plaintiff's lawyer just kept suing the staffing company and then suing the staffed businesses, right? And the staffing company had many businesses they staffed until they put the staffing company out of business. And then they just looked for the money from the facilities, said, well, look, they're out of business. You're a joint employer, you're responsible, and went on a feeding frenzy suing all the businesses. So you want to be really, really careful about who you're in business with. Okay, let's answer the next question that gets asked a lot. Could you have both a virtual marketplace or a registry and a W-2 agency? And I think that is possible, at least in some jurisdictions. I'm not going to say it's possible everywhere, because in some jurisdictions, I don't think you can have a consumer-directed model, at least not in a way that doesn't create some significant risk. But if you're in a jurisdiction that is amenable to this kind of model, I think you can have two separately incorporated businesses that are run concurrently but separately, right? Where staff does not go back and forth, particularly at the caregiver level, across the models that really look very different. They have to be run and operated differently, right? And I think that actually can be helpful when you've got separate paperwork, separate marketing, and you can really clearly define them as different options. And Derek kind of touched on this in his introduction, where we have clients where the consumer will call and say, this is what I need. And the business has both models. Says, okay, well, we've got our white glove service over here, and this is going to cost this. Or we also have this model where you are going to, direct, we can provide the caregiver, but you direct the caregiver, right? And it's a different kind of model, and we don't provide these same kind of services, and you explain that and have a script around it and really run them separately. That can actually be helpful in drawing the distinction between the two if you ever do have a DOL audit. But if your caregivers are going back and forth, right, and we can talk about, can you use office staff? Can office staff, exempt office staff be used back and forth? And I think the answer is that it depends, but in some cases they can, particularly for intake purposes, right? But you still should have them most likely assigned to one business or the other. But that gets into business formation sort of issues, and there is a good way or ways to form this entity with a holding company and subsidiaries and all that are, again, beyond the scope here, that our transactional lawyers do, not me. But you can run that model and then demonstrate to, say, the Department of Labor that they're distinct and different, and that there are fundamental differences that establish that each one is compliant in its own model type. But when you have the caregivers going back and forth, then that becomes one business in the DOL's eyes. It's one enterprise or joint employment, right, with liability, so you can infect one business with the other, just like any other joint employment scenario. Okay, so let's now just switch gears into what are the common. These are our common targets for agencies, right? The types of things that we are litigating all the time for the agency models that you really want to think about. Issues like failure to pay for travel time, work that is being done outside of service hours. That's a huge one, right? Somebody's looking at care notes, right, before they get to the client. They're confirming appointments before they leave their home, right? That's compensable work time. They stay longer than the reimbursed service hours, so the time is dialed back. Their actual time at the client is a half hour more than the authorized service hours. So somebody in the office dials that back a half hour. That's time shaving. That's a huge issue. Mileage and travel pay, that can be paid at different rates. You don't always have to pay mileage. That's a state specific issue. Manipulation of pay rates, where we're modifying rates, for example, like a live-in rate based on the number of days that the person's working, and we're shifting it back and forth to maintain a specific day rate, right? That becomes a problem. So there's, pay per visit issues are a big problem in home health, right? And how the pay per visit programs are regulated. So a lot of issues, and a lot of them are varying issues, varying by state law, right? That you've got to focus in on and make sure that you're doing the right way. So there's kind of a compliance program for agencies and a different compliance program for registries, right? Here are the ways that registries are often targeted. These are some of the things that we talked about before, right? Where the caregiver is not really in control. It's the organization. And I'm saying, again, registry, but I'm talking about any consumer directed model. If the platform or the organization is negotiating the rates, right? If the caregiver is not marketing their services, that's a factor towards that suggests employment in the mind of the government and many courts. If the organization is overly involved in the assessment of the patient, the scheduling of the services, if the organization is, we see this a ton with the name of the organizations, right? If the idea is that you're not involved in care, then maybe care shouldn't be in the name of the business. There's, sometimes not a lot that can be done about that now retroactively, but you can address your marketing materials. And you're going to say, for example, if you're a registry and you say our services are X dollars an hour, well, then who's setting the rate, right? And you're going to now argue, well, we don't set the rate, the caregiver does. Yeah, but you've got a marketing brochure that says what your rate is, right? That you give out to people. So, how are you getting to that? You've got a website that's providing all kind of information about care and medical conditions and all these things that you say that you're not involved in and that you don't do because you're just a matchmaker, right? Caregivers are often the Achilles heel of these kind of models, right? Because they sometimes see the organization as the employer, even if you're telling them that you're not the employer, right? So the way that you communicate with caregivers is essential, and there's a whole program around that you really should be focused in on. Anything that you are paying for on behalf of the caregiver, like advancing payments to the caregiver or paying for their insurance or anything like that, creates issues as well. All right, switching to compliance. I know we're running short on time here, so I want to move quickly through this. But let's talk about some common ground between consumer-directed models and W-2 models that everybody should be utilizing in this industry. One is an arbitration program. There are different agreements and programs that you would use for independent contractors versus employees, because it's a different set of claims, right, that an independent contractor would bring instead of an employee. So one thing you don't want to do is use an arbitration agreement that you've got for an employment model with independent contractors. That's almost that can be used as an admission that you think that they're employees, right? Or you wouldn't be using that kind of agreement. But in general, there are agreements that can help you to avoid class action lawsuits that are very, very effective, and you can use we have arbitration programs in every state. California has one that's unique because of PAGA claims, but there are agreements both for contractor focused agreements and W-2 focused agreements, and this is the most significant tool in the tool shed. There have been some recent changes around arbitration where, for example, you can't include sexual harassment, sexual assault claims in your arbitration program. So you want to make sure that those are excluded. We do have a program around this, those who are POSH subscribers, which we'll talk about later, but that's our tool compliance resources for the W-2 agencies. We've got the employee arbitration agreements in every state. We update these materials as the laws change. So you can see that, that highlighted language there is eliminating the sexual harassment and assault claims that have been recently eliminated from arbitration by Biden. Biden signed that into law last year. But arbitration is absolutely critical. That is the number one tool for avoiding or minimizing the risk of litigation. Next, for common compliance ground that everybody should be doing, regardless of what your model is making sure that your materials are legally compliant and your messaging is consistent and you're actually documenting your compliance measures for those good faith defenses that we were talking about. You really, really understand the law in your jurisdiction and how it's changing, that you are prioritizing timekeeping. So we have time certification for the workers. How you achieve that certification is going to vary by model, but the idea that the worker is telling us what their hours are, whether that's for making sure that you're charging the client right in a registry world, or to confirm that we're paying the caregiver correctly and complying with all the wage hour laws in an agency world. Certification is really important. And then the way that you deal with live-ins is, that's critical, because the live-in is the most likely position in a 1099 model to be deemed an employee because of the number of hours that are worked, right? And there are some compliance methodologies for live-ins that will move the 1099 or consumer-directed model from 0 compliance to 100% compliance without changing the labor costs.
Okay, great. So Airtime is a software company that supports W-2 and the consumer-directed home care model. And it does everything mentioned beneath here: CRM scheduling, electronic visit verification. But what we've done is we actually click the next slide. We have a completely separate platform specifically for registries. Okay, so this technology was built by home care agency owners. The company's been in business for several years, and we have hundreds of clients who are using it. Angelo mentioned a lot of things that will get you in hot water by running a registry. And so we're not advocating here that by using a software, you will be compliant, because as Angelo mentioned, the way in which you treat the caregivers and all the other tests will determine if you are compliant. However, Ally was built to help support staying compliant with a lot of the areas we know are hot buttons. So we actually had a question that was just typed in. Let's see. The question was, this was from Akin. How can I start my nursing staffing agency in Florida, and what are the requirements? So we'll double back to that question as well. You'll need to get licensed. You'll need to get caregivers. You'll need to set up a separate entity, and Angela will go over some of those requirements. But if you already have an agency today, you want to use a separate software system. And as Angelo mentioned, you don't want to be in what we call the funds flow. You want to be able to look to a company like Ally and say, they're collecting the payment from the family member. They're separating it out and they're paying the caregiver, and then I get my referral fee portion, right? So if we go through the check boxes here of what Ally does, so imagine it's a scheduling software, right? Now, all the terminology inside of Ally is friendly for registries, because I have seen certain compliance situations where caregivers take screenshots of a software. And if your software says, certain terminology like employ or hire or pay, right? Those little nuances can be sometimes those like smoking guns. So the top benefit here is whatever core system you're using to schedule for your W-2 and agency model, you can keep it. Now, I just mentioned we own Care Time as well. So that is a W-2 agency model, but to add in a consumer-directed model, you do not have to replace what you are currently using today for your W-2 or agency model. So you keep that core scheduling system. But once you set up your separate entity, you get all the compliance stuff set up that Angelo can support you with, then Ally helps within the software negotiate the rates within the software. So this facilitates and documents the conversation and the rate setting process directly between the family member and the caregiver. I also mentioned all the terminology in the software, right? Sometimes just those very little nuance. Imagine these auditors who come in who are overworked, understaffed. They're looking at a complaint, and there's all sorts of things that they're going to look at. But if they look in the software system, and again, if it says there's a little button that says, hire, or when you are scheduling that person, if you don't offer the shifts, right? What contractors do, kind of like Uber drivers, is they get to choose if they want to accept the shifts that are sent to them, or the assignments, the requests that the clients have offered. So all that little terminology is considered here. Ally also collects the funds from the family under our entity. We separate the funds and then we pay the caregiver, and what's left is your referral fee. Okay. Now, on the back end of that, Ally also issues the 1099K under our company name, such that your entity name is not on that. And we actually held a completely separate webinar. Ally did with Angelo back in the fall. There is a whole webinar on this topic, that the threshold for sending out 1099K has moved and is continuing to move. There's a little bit of kind of moving target on this, but from approximately $20,000 to $6,000. I mean, this impacts really anyone, including if you're paying a babysitter, someone to mow your lawn, but especially including it dramatically lowers the threshold for actually having to issue the 1099K. And so if you are interested in running a registry, you do not want to be in the funds flow. You want Ally to collect the payment from the family, to pay the caregiver directly, and then to issue the 1099K at the end of the year when it's tax season. We have a standard time clock feature as well. However, the Ally's flavor of this is that the families and the clients get to approve the time cards, right? You as a caregiver registry, you're not getting involved. The caregiver was late. you're not running discipline, you're not sending alerts and notifications, to the caregiver. It's the families need to review and approve those time cards. And then when that happens, then all caregiver support and billing inquiries are handled by Ally, right? So you don't want to be in the position where the caregiver says, yeah, well, my employer is this registry because when I don't get paid on time, I call them and they handle it for me. You want our support staff to be able to handle that and have documentation that we're supporting predominantly most of the payroll related inquiries if they have any issues or input their bank account incorrectly for getting paid. Next slide. So I think Angela, this was a slide I think you had in here, but I think you covered it as well. So I think we want to strike up the poll here. And so we're gonna throw a poll question up, and then we're gonna turn it back to Angelo. So you can look on the Zoom panel. You should see a poll. Now, note your response is not public to the webinar audience. Only us as hosts can see. This is just a lot of you have questions in the chat. How do I get started? What are some of the things that I need to do? So if you'd like to understand more about what Ally can do, if you're interested in adding a registry onto your business and interested in how that software differs, or maybe you're running a registry today and you're using the same system today, or you're not separating the funds flow, you can just put in that information. We'll give it a few seconds. I'm sure there's a few wild mavericks.
Can you hear me again?
Yes.
In the back? Okay, good.
Excellent.
Yeah.
We'll go back to your slides here in just a moment, Angelo.
My headset is an hour presentation too, I think.
That's all right. Everyone was very patient with us, so we appreciate it. Okay, we can go ahead and close the poll. We'll see the results. Excellent. All right. We have a few folks who are interested. We have a few wild mavericks and a few people who are undecided, and that's great. And probably a first portion of where you're going to want to start is talk to Angelo. So I'll pass it back to Angelo to talk about how he is supporting businesses who want to offer multiple models.
Great, thank you. Hopefully you all can hear me all right. I apologize for that. I think what I'll do is let's launch the poll and I'll kind of explain what I was saying before when you couldn't hear me. But I promise you it was amazing. If you had been listening, you'd be like, that's the best thing I've ever heard. It was that good. And unfortunately, you missed it. But what I was saying is that we have solutions for every type of model. The slide I think I probably lost you on was the compliance review for registries. And what I was saying that for registries, there's not like a set of materials that you just buy and use, right? The materials really there are templates to start with, but those are modified based on your practices, right? And what you do. So that kind of review is more of a consultation where we sit and talk with you about what your practices are, identify those ones that are problematic. And then if I'm sure you've got materials you use, we either update those materials to be compliant with those practices or substitute templates, things that you should be using that you either don't have, like arbitration agreements and the like. With respect to the agency model, we have POSH, right, which is Personality Online Solutions for Home Care, which is really only for W-2 agencies. But the concept here is now we do have templates that you can use, and you can often use these templates without the need for consultation. So this would be things like a handbook that is compliant in your state, California or Florida or wherever it is. There's a handbook for every state, and offer letters and live-in agreements and all those types of things that are available to you. So if you have an interest in learning about any of those, and then for the virtual, I should have mentioned the others, virtual marketplace, and those that are involved in consumer directed programs or staffing relationships, right? We do work around staffing agreements, licensure, where we will help the consumer directed models to identify what jurisdictions they should be in, what their terms and conditions should look like, right, on their website, building an arbitration program directly into those terms and conditions, or standalone agreements with caregivers and clients and things like that. So we really are here to help and serve every model. We do everything that we can to make it price effective. And whenever we set up a compliance program with an organization, we like to keep it on that schedule. I don't know if you heard me say that or not, but that once you have done this and you've done the work to develop a compliant model, keep it on a review schedule so that when the law changes, you can quickly and easily update your materials to use on a go-forward basis that remain compliant. I think what a lot of companies do is they wait and they will do a major project, compliance project, and then kind of leave it and then do it again in 3 or 4 years. And you have this flow in and out of compliance. It's pretty easy to set up on a schedule once you have the compliant materials. So with that, I think we can close the slide and close the presentation. I know we went a little long. We got most of it recorded. Some of it's a little dead zone. We'll figure that one out. But really, really appreciate your time. Derek, thank you for the putting this on. I think it's hopefully very helpful to everyone.
Yeah, it is. I know we're over, so if you're with us because we're way over anyways. Angela, I do have there are some consistencies in a couple of the questions.
Yeah, sure.
I just want to ask this one question, and then for any of you who have typed a question, we will respond to you directly. So we know we've just kind of cut out of time. But let me ask Angelo a question. Angelo, some of the largest home care businesses in the country run a dual model. They run an agency and a registry. And some of them, you may have clients with some of them, but I'm curious to get your perspective, like what is making them so successful? Because they're typically not small operations, they're fairly large operations, but they have to do it right, of course. But in your working with those large companies, how are they making it work with a dual model such that they've not only are growing, but they're sticking around for a decade plus?
Yeah, great question. I think the big models really spend time on being focused on compliance, right? On how do we run this model? How do we do it in these jurisdictions? Where do we need to pivot away from the model or tweak the model in such a way that minimizes our risk? But there's a tremendous amount of work that goes into that prep analysis. We're working with a business right now that's launching kind of an alternative model all across the country, and we spend time, analyzing the licensure requirements, figuring out what license do we need to have, right? Is it a jurisdiction we should avoid altogether? Is there maybe there's an overtime component, or we need to pay into unemployment for this model to minimize risk? Let's make sure we've got the right arbitration program. But there's a lot of effort. It's not that they just turn the model on. There's a lot of effort focused on how do we separate the two? How do we communicate to our potential clients as to what their options are? But I think that's how that's being done, right? And they generally are, whether it's separate entities, or some other way to develop separation between the two lines. You can normally see that. You often see separate websites, right, and marketing material for one versus the other, and kind of the thing I was talking about when we were on the dual model discussion of you can actually use that as an advantage if you can really demonstrate how you truly treat those things as two separate animals.
Yeah, that's great. I remember when I ran a home care business in Pennsylvania, when I first got into this space, we had a dual model. And thankfully, I mean, we treated it as two separate businesses. And I think I would just layer that on top. It's an investment. I think if you try to take your existing agency and just say, well, we're going to just use all the same caregivers and the same staff. And there certainly are some synergies between having some infrastructure and knowing the business in your market. But we had a separate office, right? And we had a separate staff member who was helping source those caregivers. And we had to make that investment in the team. And some months the agency would be up and the registry would be up, right? And so we just had to treat it like a completely separate business. We couldn't sort of cheat in that respect. But it enabled us to have that conversation when the client called and said, look, remember at the very beginning, we said the goal of home care is to keep people home, right? We want to keep them safe and keep them at home. And so we would have that option. Now there's tons of questions.
What we're seeing a lot of companies do, just to put a pin in that point, is keep their options open, right? So I mentioned that we're seeing a lot of agencies pivot or add virtual marketplace type services or app type services to their product lines. But we also see registries now with the focus on independent contracting at the DOL going out and getting, traditional home care licenses, even if they're not going to operate that way yet, right? So let's go through the application process and be ready. And, if we need to pivot and move folks over to a W-2 model, we'll be prepared and available to do that. So you really see a lot of shifting, and it's not necessarily, picking one over the other, but it's having multiple arms, even if they're not quite active just yet.
Yeah, excellent. We have several questions that will require follow-up. I'm not going to triangulate the questions directly to each person because some of them might be sensitive, but Akin asked a question. Julie, there's a question about, hey, my franchisor doesn't offer a registry. Can I offer that? Does it break the franchise agreement? I'm sure Angelo will follow up with you on that. Obviously, we want to work with franchisors. Maybe it could be an additional business line for them. We have some individual questions from New York. Some questions. We have some Ally customers who are on who looks like they might just need a couple updates on some recent product releases that we have as well. So I'll forward that to our team, and some very specific state nuances. So we're already operating on negative time here. We will collate the resources. For all that, I just want to thank Angelo and the Polsinelli team and all the cast of characters who are behind the scenes. There was about 3 or 4 people involved at Polsinelli to put on a webinar like this, including Claire for co-hosting and being the moderator today.
Thanks,
so with
Claire.
that, yeah, thank you everybody, and hope you have a great week, and we'll be in touch.
Thank you all. This concludes today's webinar. A recorded version of the presentation will be sent to you via email within 72 hours. And thank you for your participation.